All right, Judge, we definitely appear to be doing some background movement, so give me a few more minutes, please.
Sounds good. No worries.
Judge, you are clear to proceed.
Sounds good. Now, I know this is your all's fourth round, so I'm supposed to remind you of certain things, and I'm just going to give you the quick version of it. Of course, this being the Colorado State Championship, or tournament, I should say, the Colorado Association, the Colorado Bar, has the privilege to take photos of you all and take recordings and post them to their discretion. There will be no recesses throughout this trial, except for emergency situations, which do include bathroom breaks. However, I will be allowing scoring panelists some time in order to write down scores after parts. So if I ever say, let's just give them 15 seconds before we proceed, we'll just allow the scores to be entered in. Now, let's get everyone sworn in. So, will team members please come on screen? Will you all raise your right hand? Team members, please raise your right hands. Do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
Alrighty, witnesses, will you please come on screen? Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
All righty. We don't have any gallery members, so let's go on to scoring panelists. Will you come please on screen? Please raise your right hand. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Do.
Yeah, I do.
Okay. I'm sure there will be pretrial matters to attend to, but before we get started with those, would both parties like to make appearances before the court?
Yes, Your Honor.
Go right ahead.
Your Honor, opposing counsel, and members of the jury. My name is Jada Inks, and I will be delivering the opening statement, giving the direct examination of Alex Cifuentes and the cross-examination of Blake Van Owen.
Your Honor, members of the jury, and opposing counsel, my name is Brendan Maher. I will be delivering the direct examination of Kyle Kuzak and the cross-examination of Taylor Perkins.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Will Damon, and I will be delivering the direct examination of Jordan Markowitz, the cross-examination of Avery Becker, as well as our closing argument. Your Honor, at this time, our witnesses would like to introduce themselves.
They may go ahead.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is V. Wing, and I am Detective Jordan Markowitz.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Jet Fisher, and I am Kyle Kuzak.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Christian Murray, and I am Alex Cifuentes.
Your Honor, may the defense introduce themselves.
Of course.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Claire Kenny, and today, along with my co-counsel, I represent Avery Becker in the matters of the state versus Avery Becker. Today, I will be performing the direct examination of Professor Blake Van Owen, the cross-examination of Mr. Kyle Kuzak, and giving the closing argument. Permission for my co-counsel to introduce themselves.
They may.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Olivia Aguirre, and I will be directing Avery Becker and doing the cross-examination of Detective Markowitz.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Garrison Ebel, and today I will be delivering the direct examination of Taylor Perkins, the cross-examination of Alex Cifuentes, as well as the opening statement. Your Honor, may I have permission for my witnesses to introduce themselves?
You may.
Thank you.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Charlie Jones, and today I am Avery Becker.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Galilea Landa Posas, and today I am Taylor Perkins.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Grace Trembath, and I am Professor Blake Van Owen.
Well, good morning to you all. Prosecution, do we have any pretrial matters to attend to before we get started today?
Yes, Your Honor. On behalf of both teams, let the record reflect that my co-counsel will be posting our trial rosters in the chat for you, the jury, and for the purposes of exchanging trial rosters as a preliminary matter. Also, let the record reflect that we will also, both teams have agreed to stipulated facts for this case and will also be entered into the chat for yourself and for the jury. Your Honor, we request the court's preferences on recross examinations.
For recross examinations, let's try not to do them. If there is some substantive point that you think needs to be made, absolutely go ahead. But just for the sake of time, let's try to avoid them.
Your Honor, pursuant to competition rule 7.4, we ask that when an exhibit is shown to a witness, the member of the examining attorney's team will be able to pull up that exhibit using the Zoom screen share function. Additionally, All exhibits or other documents posted in this manner are deemed to not have been shown to the jury unless counselor specifically asks for them to be published. Also, according to competition rule 4.7, no additional enlargements are to be made outside of today's trial or edits to documents. Only will be accepted if they were done during the Zoom meeting with the annotation tools provided.
Defense counsel, is that your understanding of the rules?
Yes, that all sounds perfectly fine to me.
Your Honor, we understand that sound quality and internet connectivity may vary at all times throughout this trial, and we ask that if on any attorney or witness on our side or opposing counsel is having issues with internet connectivity, that the court pause all proceedings and allow that witness or attorney to come back and answer or ask their questions in the full capacity of their abilities to.
Of course.
Your Honor, we request that our timekeepers be able to post our time remaining in the Zoom chat function throughout the trial to help you and ourselves keep pacing throughout this, as it is a timed competition.
Any objection, counsel?
No objection, Your Honor. I would ask opposing counsel's views on our timekeeper previously has held up time cards at each 5-minute intervals through the camera function. Is that something that opposing counsel would be all right with? Just to get their thoughts on that.
Absolutely.
All righty, then we'll allow for both times to be in the chat and on screen.
And Your Honor, as the prosecution, we ask that all time remaining on closing argument be reserved for rebuttal.
It'll be reserved.
That is all. No further preliminary matters.
All right, defense, do you have any matters to attend to?
Yes, just a few more, Your Honor. We want to seek the court's permission to deem that any exhibit that is shared by means of screen sharing to lay foundation with a witness to have been constructively handed to opposing counsel for their review.
Yeah, we'll assume that it's constructively handed to opposing counsel and hasn't been published to the jury yet.
And we also ask that the court defendant may constructively sit at the counsel table for purposes of conferring via Zoom chat with his counsel and thus serving as the defense advisory witness.
I'm assuming you're talking about the defendant?
The defendant, yes.
Yes, absolutely.
And those are all of our preliminary matters, Your Honor. Thank you.
Sounds good. With that, I believe we can proceed to opening statements. So prosecution, you may proceed when ready.
A moment to readjust.
Of course.
Your Honor, opposing counsel, and members of the jury. My name is Jaden Inks, and my co-counsel and I are here today on behalf of the people of the state of Colorado. Today, we are going to illustrate how Avery Becker became undone, unraveled, and in the end, unmasked. On March 6th of 2020, a tragedy occurred. Mackenzie Brackman, a beloved coach and well-respected attorney, was found dead in his home. This crime was committed by Avery Becker. On March 6th, Avery Becker broke into Coach Brackman's home, intending to cause destruction. Avery, upon entering, found that Mr. Brackman was there. Avery and Mr. Brackman then engaged in a physical struggle in which it is our assertion that Avery Becker took a knife and stabbed Mr. Brackman in the upper left-hand shoulder, nicking his aorta and causing him to bleed to death in the front entryway of his own home. After leaving Mr. Brackman dead, Avery Becker then fled the scene. The relationship between Avery Becker and Mr. Brackman spanned 4 years, the time that Avery Becker was on the mock trial team at Colorado High School. In this relationship, bad blood was a constant. Mackenzie Brackman and Avery were in constant disagreement about Avery's preparation for competition on the team. Often, Avery demonstrated a lazy work ethic, was late to practices, and put the team in difficult positions. Mr. Brackman then was forced to be hard on Avery and encouraged him to work harder and called out her persistent harmful antics, leading to their relationship becoming undone. Confrontation was not something that Mr. Becker liked, and this led to him beginning to unravel. Unable to meet Coach Brackman's expectations moving forward, Avery was then demoted to a lower team. As a result of being demoted to a lower team, Mr. Becker got his friend Taylor Perkins to quit, then forcing Mr. Brackman to reinstate him onto the A team. After the regional competition, Mr. Brackman then confronted Avery about their persistent harmful antics, and that again asked that he needed to improve before the state competition. Avery took this as an attack against him, leading to a reckless decision motivated by his need for revenge. Avery wrote across the top of his coach's Porsche, "Worst Attorney Award." In seeing this, Mr. Brackman was upset. This was the boiling point, the last straw, and Mr. Brackman kicked Avery off of the team. Avery, now undone, unraveled, and unmasked, committed his crime. Today, we, the prosecution, will put forward 3 witnesses. Detective Markowitz will testify to how Mackenzie Brackman was killed, providing you with an expert opinion on homicide investigation from her years of experience at the Denver Police Department. Markowitz will walk you through the events that happened on the day of March 6, 2020 that led to Mackenzie Brackman's tragic death. Detective Markowitz will point out Avery's opportunity in committing his crime by explaining her experience with cell phone technology, and will help you understand how cell phone data analysis put Avery Becker at the scene of the crime. Kyle Kuzak will present evidence that proves a scuffle occurred when Avery Becker broke into the home. This evidence will detail the means to which Avery Becker's revenge led to the killing of Mackenzie Brackman. Finally, Alex Cifuentes will testify to her personal knowledge on behalf of the defendant as a fellow team member and student of Colorado High School. Alex Cifuentes will help explain what motivated Avery's revenge and will unmask Avery in the end. Avery Becker is charged with murder in the 1st degree and 2nd degree burglary of a dwelling. It is not our duty today as the prosecution to prove to you Avery Becker's intent in killing Mr. Brackman. Instead, we will prove to you that Avery Becker broke into Mackenzie Brackman's home with the intent of causing criminal mischief, and a death occurred. Today, the prosecution carries the burden of proof, a burden that we will absolutely be able to meet by undoing, unraveling, and unmasking Avery Becker decisions on the day of March 6, 2020. At the conclusion of this trial, we will come back and ask you, the jury, to return a verdict finding Avery Becker guilty of all crimes. Thank you.
Thank you. Defense, do we have an opening statement?
Yes, Your Honor. May I proceed?
You may.
Thank you. Reckless, rushed, guilty until proven innocent. Members of the jury, do those sound like the descriptors of an honest, well-looked-into police investigation? Today, we are going to show you the reality of Detective Markowitz's investigation and the falsity of the prosecution's story. Today, we are going to tell you about Avery Becker. Avery graduated from Colorado High School in June 2020. But instead of celebrating and moving on to the next stage of his life, the police chose Avery as their suspect for a felony murder and 2nd-degree burglary. Today, members of the jury, it is your job to listen to the facts of this case. The burden of proof lies on the prosecution. They must prove to you beyond a reasonable doubt that Avery Becker is guilty of these crimes. And per jury instruction number 2, if you cannot find evidence of Avery's guilt beyond a reasonable doubt, you must find him not guilty. Now, members of the jury, you will hear from the prosecution today about their investigation and their conclusions. We will show you that those fragile conclusions came only from faulty evidence, mistakes, and a rush to condemn a suspect. You will hear that the police heavily relied on the testimony of one mock trial team member, where they received their first and their only suspect, Avery Becker. They never looked into other suspects who had significant reasons to be angry with the victim, and they relied on video clips that show only a person in a mask entering and leaving the victim's house, and relied on potentially faulty text messages and cell site data. But, members of the jury, let's start at the beginning. You will hear from 3 witnesses today. Avery Becker himself, Taylor Perkins, Avery's best friend who was with Avery on the day of Coach Brackman's murder, and finally, you will hear from private investigator and Professor Blake Van Owen. Avery will tell you that yes, he and Brackman did have arguments with each other, but he would never commit murder over petty squabbles. You will see Avery is a talented student, a good friend, and a lover of mock trial. But he was also a high schooler, and high schoolers make mistakes, like angrily drawing on a car with what turns out to be permanent marker. Members of the jury, you will see that Avery could not have been pushed so far as to commit murder. Furthermore, you'll hear from both Avery and his best friend Taylor Perkins that on the day of the murder, they were looking for Avery's lost cell phone, scouring the places they had been the night before. You'll see that neither of them could have been at the scene of the crime. Finally, you will hear from Professor and private investigator Blake Van Owen that the police came to the easy conclusion regarding the murder of Mackenzie Brackman. She will show you the assumptions made by crime scene reconstructionist Kyle Kuzak and the mistakes made by Detective Markowitz. She will explain to you that yes, there is physical, on-scene evidence that an intruder broke into the home of the victim, but that the police fit this evidence to Avery instead of letting it lead to their victim. In regards to the location of Avery Becker's cell phone, Professor Van Owen will share that cell tower data cannot definitively locate a phone, and that Detective Markowitz never looked into any other cell site data other than Avery's. Again, members of the jury, the prosecution has the burden of proof today. They must prove to you, beyond a reasonable doubt, that Avery Becker was at Mackenzie Brackman's house on March 6, 2020. That he committed criminal mischief, committed second-degree burglary, and, in doing so, murdered Mackenzie Brackman. And so, members of the jury, as you listen to Avery and Taylor tell you the story of March 6th, as you listen to Professor Van Owen explain all of the discrepancies of the investigation, you must ask yourself, is Avery innocent until proven guilty? Or has this investigation made him guilty until proven innocent? Thank you.
Thank you, counsel. We're just going to give a little bit for scores to be entered, and then we'll proceed. Alrighty, prosecution. Do we have any witnesses to call today?
Yes, Your Honor, the people are going to call Detective Jordan Markowitz to the stand.
Good morning, Ms. Markowitz.
Good morning.
Good morning. Please state and spell your last for the record.
Jordan Markowitz, Markowitz.
What do you do for a living?
I'm a homicide detective of the Denver Police Department.
And how long have you worked for the Denver Police Department?
I've been with DPD for 13 years and 7 years as a detective now.
What sort of certifications do you have as a detective?
I have a cell phone technology and forensic data recovery certification from the American Academy of Law Enforcement.
And what does that certification help you do?
Well, it instructs you on how to acquire and interpret different types of cell phone records and data, cellular data, and cell tower data.
How often do you use your certification with your job?
I use it on a regular basis. In fact, I've used my certification in over 50 cases in my career.
Your Honor, at this time, pursuant to Rule 702, I move for the admittance of Jordan Markowitz as an expert in homicide investigation with an emphasis on cell phone technology.
All right, defense.
No objections, Your Honor.
Okay, then the Detective Markowitz will be entered as an expert.
Let me take you back to the events on March 6, 2020, the day that Mackenzie Brockman was murdered. Where were you on that day?
Well, on March 6th, we received a report from a passing motorist who saw a person possibly passed out at 444 South Flower Street in Denver County, Colorado. Officers and I were then called in to investigate.
And what type of address is 444 South Flower Street?
It is a residential property.
And when you got to the residence, what did you see?
Well, when officers and I arrived around 2:20 p.m., I noticed that the front door was open, and inside the front door, we found the victim deceased and a large kitchen knife nearby. The victim was later identified through his ID as Mackenzie Brockman.
Your Honor, at this time, I ask permission to show the witness was marked as Exhibits 1 and 5.
Any objection?
No objections, Your Honor.
All right, then you can show them.
Now, Detective, what are these exhibits?
These are crime scene photos of the large knife as well as the victim, Mackenzie Brockman.
Are these fair and accurate representations of what you saw on March 6th?
Indeed, they are accurate.
Your Honor, I move for the admittance of Exhibits 1 and 5.
Defense?
Objection, lack of foundation.
To which exhibit or both?
To both exhibits, neither the attorney or the witness has really stated what either exhibit is or how it is in connection with their case.
Okay, response prosecution?
Your Honor, I have to disagree with opposing counsel. I asked the question, what are these exhibits? And my witness has said that these are photos from the crime scene that her team took. And that's adequate foundation with being authenticated as well as laying the proper foundation for these exhibits.
Yeah, I tend to agree with the prosecution. Defense counsel, what more foundation would you want laid?
Maybe just a few more questions instead of just one.
Okay, I'm going to overrule that objection. I think the foundation has been laid for these, and if he's going to talk, if the witness is going to talk about what's on them, and they need to be tendered to the jury. So overruled.
Okay.
Your Honor, I move for the publish these exhibits to the jury.
Go ahead.
Now, Detective, after you examined Mackenzie Brockman's body, what did you do?
Afterwards, I noticed that the property had several ring cameras, so I then observed a side gate was unlatched and as well as the back door was open and unlocked.
What happened after you found the back door unlocked?
I then entered through the back door into the kitchen to find the residents in slight disarray, a broken plate on the floor, a knife drawer open, and blood drops on the floor.
And after you examined the kitchen, what else did you do?
I continued to search the residence and noticed nothing of value was missing, and there were no other victims on the property.
When you after you searched the residence, what else did you investigate?
Mackenzie Brockman had a cell phone, so I then downloaded the contents of his phone, which gave me access to his Ring security camera account. On that account, I found 4 videos of a hooded and masked individual that entered the residence.
And after you searched the phone, what else did you do?
I also found that Mr. Brockman was a coach for a school activity mock trial, so I then spoke with a mock trial student named Alex Fuentes, who provided me screenshots between her and another student, Avery Becker, of a text conversation.
Your Honor, at this time I ask permission to show the witness what has been marked as Exhibit 14.
Go ahead.
And Detective, what is this exhibit?
These are the screenshots of the text conversations I received from Alex Fuentes.
And is this a fair and accurate representation of the conversation between Avery Becker and Alex Fuentes?
They are indeed accurate.
Your Honor, at this time I move for the admittance of Exhibit 14.
Defense?
Here, hearsay, and additionally, these are the old version of the exhibit. There has been an updated version on the website.
Okay, let's take these issues one at a time. Let's start with the issue of this possibly being an older version. Prosecution, what do you say?
Your Honor, I believe that this is the most updated version, but if not, we can pause the time and get that updated version for the jury. But other than that, I believe that this is most recent.
Defense counsel, let's say that this is an older version and that a newer version exists. Is there a substantive difference between the two?
Well, the text me in the top left corner would not be there, and that could change some aspect of the case.
So, Judge, I'm sorry, this was actually brought up yesterday too. This was a completely administrative thing that was done by the mock trial staff. They had something with a text me app that changed things, so they had to redistribute an updated version.
Courtroom monitor, do you think that we should pause time for a bit to allow them to be updated, or do you think we should proceed?
I would definitely pause time at this moment. Do either of the teams have the updated version?
Our timesharer could pull it up for you guys if you would like that.
That's what I would recommend, Judge.
Okay, then let's have defense's timekeeper pull up that exhibit, and prosecution, if you want to update them for further direct examinations, let's do that while this one's going on.
Yes, Your Honor.
Okay, now let's go to the objection over hearsay. So, prosecution, what's your response to the hearsay objection?
Your Honor, pursuant to Rule 801D2, this is a statement made by the party opponent, which is definitionally not hearsay.
Okay, response to 801D2, defense.
Well, we have no proof that this could truly be Avery, even though it does have the contact name. It could have been falsified, and it still could not have been from the opposing party. And also, you're claiming it is from Alex, who is a witness on your side. Therefore, it is hearsay.
Okay, so prosecution, what do you have to say to the statements of Alex being hearsay?
Your Honor, certain statements in the green are not being offered for the truth of the matter asserted. However, there are certain statements that are being offered for the truth of the matter asserted. However, these fall under the exceptions 801.3.1 and 803.3 as present sense impression and then existing state of mind.
Counsel, which ones are being offered for the truth of the matter asserted?
Your Honor, if I may have a moment, I believe the only one that is being offered for the truth of the matter asserted is, I guess I could try, but after the car situation, I doubt anyone could change his mind. I believe that's the only statement being offered for the truth of the matter asserted. And as it is being said in the present tense, 803.1 and 803.3, present tense impression, as well as an existing state of mind, apply to as an exception to this hearsay statement.
Okay, I'm ready to rule. So these are opposing party statements. So I'm going to allow Avery Becker's statements in. I'm going to allow in the statements that aren't for the truth of the matter asserted with a limiting instruction to the jury that they are not for their truth value. And I'm going to include in that the statement that you just mentioned, prosecution, because I don't believe that 803.3 nor 801 cover that. So all of these other statements are going to be with a limiting instruction that they are not to be taken for their truth value. So you may proceed.
Your Honor, at this time, I move to publish.
Go ahead.
And your timekeeper can take that exhibit down. Now, Detective, in your expert opinion, what do these text messages suggest?
Well, they suggest that Avery Becker planned on breaking into the residence of Mackenzie Brockman.
And after you received these screenshots, what did you do?
Well, I then tried contacting Avery Becker to interview him, but I was blocked by his attorney. But after that, I got a search warrant to search Mr. Becker's phone.
And what did you find with his phone?
I didn't actually find Mr. Becker's phone, as I learned from his attorney that the phone had been lost. So this prompted me to get a court order to search Mr. Becker's cell provider records instead.
What did you find with the cell provider records?
I was then able to access call detail records, or CDRs.
And what are call detail records?
CDRs are records that a service provider collects when a phone connects a cell tower. So it shows the location of a phone, but it can't detail what is said in these communication, as CDRs details whether a call or text was sent out or received.
And how do cell phones interact with cell towers?
Most of the time it connects to a nearest cell tower, but on unlikely occasion, it can connect to a different further away tower.
And what call detail records did you find concerning Avery Becker's phone?
On March 6th, leading up to the time of Mackenzie Brockman's homicide, Mr. Becker's phone received numerous communication that went through 3 cell towers that I detailed in a diagram.
Your Honor, at this time I ask permission to show the witness what has been marked as Exhibit 15.
Go ahead.
And Detective, what is this exhibit?
This is the diagram I created with Avery Becker's phone call detail records.
Is this a fair and accurate representation of your diagram?
It is accurate.
Your Honor, I move for the amendments of Exhibit 15.
Any objection?
No objections, Your Honor.
All right, then they'll be admitted.
Your Honor, I move to publish at this time.
They'll be published.
And Your Honor, I ask permission for my witness to be allowed to annotate this document for the purposes of the jury understanding her demonstrative with the expert opinion.
Go ahead.
And Detective, can you elaborate on the call detail records that you found concerning Mr. Becker's phone?
Of course. So at 12:47 p.m., Avery Becker's phone received a text message at cell 1227-3, which is closest to Mr. Becker's house. And then at 12:55 p.m., Avery Becker's phone received another text message at cell tower 1191-1.
And what does that all signify?
Well, this was correspond with Mr. Becker's most ideal and logical route along Rock Creek Parkway to the residence of Mr. Brockman, as I have detailed for the jury to see.
And what other call detail records did you find concerning Mr. Becker's phone?
Yes, another call was received at 1:05 p.m. This was unanswered, as well as a different call at 1:06 p.m. and a final text message at 1:17 p.m. All 3 of these communication went through cell tower 1197-1, which is closest to Mr. Brockman's residence.
And in your expert opinion, what do these call detail records indicate?
Well, it's clear that from 1:06 to 1:17 p.m., Avery Becker's home phone was in the vicinity of Mr. Brockman's house.
And finally, Detective, did you formulate an opinion on what happened in Mackenzie Brockman's home at 444 South Flower Street on March 6th?
Of course I did.
And before you let us know what that opinion is, what factors did you rely upon?
Well, I relied upon my training and certifications to thoroughly investigate the death of Mr. Brockman.
And what evidence did you rely upon?
I relied upon all the evidence I gathered in this case, but heavily on the CDR, since it suggests that Avery Becker's phone was in the vicinity of Mr. Brockman's property. Additionally, the screenshots suggest that Mr. Becker's plan to break in and trash the property of Mr. Brockman.
And Detective, what is that expert opinion?
It is clear that Avery Becker broke into Mackenzie Brockman's residence to burglarize and trash the property. However, this plan was undone when Mr. Brockman confronted Mr. Becker, resulting in an altercation between Avery Becker fatally stabbing Mackenzie Brockman.
Thank you, Your Honor. I have no further questions at this time.
All right, any cross-examination?
Yes, but before I start, may I take a few seconds just to set up?
Of course.
Good morning, Detective Markowitz.
Good morning.
You headed the investigation for this case, is that correct?
Yes, that is.
You are in charge of all the decision making?
In a sense, yes.
Deciding who to talk to?
That's right.
What potential evidence to gather?
I looked at and followed all the evidence in this case.
But you lost some of this evidence, didn't you?
Unfortunately,
Now, let's start at the very beginning. You were called to Mr. Brackman's house to investigate his death, is that right?
yes, that's right. On
And-
March 6th of 2020.
Sorry, I didn't mean to interrupt you. And after investigating a little bit, you found that he was a part of mock trial?
Yes, that's right. As I said in my testimony, he was a coach.
So the first place you went to look into was the high school.
I followed the evidence that was on his phone that led me there, yes.
To talk to the mock trial team?
That's right, as I followed all the evidence in this case.
But you only spoke to Alex Cifuentes.
Right, as when I tried speaking with Avery Becker, his lawyer blocked me.
Right, but you didn't speak to any other student lawyers on the mock trial team.
No, as the evidence didn't lead me there.
Or any other student witnesses?
No,
And you didn't speak to anyone else at the school.
I didn't.
Now, Miss Cifuentes told you about Mackenzie's Brackman's dealings with Mr. Becker, is that right?
Yes, she did.
And as a result, you felt that Avery Becker was a suspect.
Oh, Mr. Fuentes provided me those screenshots, so I further investigated and led me to the most prime suspect of Mr. Becker.
Right. And when she showed you these screenshots, she didn't have her phone, did she?
Unfortunately not, but when people are interviewed by the police, they can get nervous and do an unusual thing like forget their phone.
So you told her to go home and send the screenshots when she got there.
I did, as I didn't find a need for her to come back into the department.
So you never saw the text with her in person?
I did not.
Now, I'd like to talk about another part of your investigation. You conducted a cell site data recovery investigation for this case, is that right?
Yes, I did.
And you concluded that Mr. Becker was at Mr. Brackman's house on March 6th?
Yes, I did, as you heard.
However, does it actually show that Mr. Becker went to Mr. Brackman's house?
No, but it would be the most logical route from Mr. Becker's house to take Rock Creek Parkway to Mackenzie Brackman's residence.
But does it show Mr. Becker even entering Mr. Brackman's house?
No.
And based on this data alone, you have no idea who physically possessed a cell phone on March 6th.
No, I don't have evidence of that, but I strongly believe that A.B. Becker had his phone that day.
And isn't it true that cell phones don't always connect to the nearest cell phone tower?
No, as in unlikely cases, it can connect to a different tower if that tower is busy and overloaded. I don't think that it's likely in this.
But it is possible for a phone to connect to the not nearest cell phone tower, yes or no?
Yes, possibly.
Now, Mr. Becker was very clear about his whereabouts on March 6th, looking for his phone with his friend Taylor Perkins. But you didn't check Miss Perkins' CDR to confirm their alibi, did you?
I didn't.
And didn't you say that you have downloaded the contents of literally hundreds of cell phones?
Yes, in my affidavit.
But you didn't do that for this case for Miss Perkins, did you?
I didn't find a need to, as well, the most prime suspect is A.B. Becker.
You didn't think it was important to confirm the alibi of the main suspect?
No?
That's okay. Now, let's go back a little bit. After investigating the house on the first day, did you go to any of the stores or restaurants that Miss Perkins or Mr. Becker said they went to?
I did not.
So you didn't go to the Fry Shack to see if they'd been there?
No.
Or to the mall?
No.
Now, lastly, I think we can both agree that you investigated very few suspects in this case. Is that right?
Well, all the evidence led me to Avery Becker.
But didn't you say that Mr. Brackman's death was most likely the work of one of his disgruntled ex-clients?
I did, but as a thorough detective, I followed the evidence and it didn't lead me to any of his past client, but to Avery Becker.
And didn't you also say that it was highly unlikely that Mr. Brackman's death had anything to do with his mock trial activity?
I did, but although it seemed highly unlikely at the time, it's clearly I was wrong then.
And despite all this, you still felt that Avery Becker was to blame.
Yes, as the CDRs, as well as the text message conversation and other evidence proved it.
And about those CDRs, can we pull those up really quickly? Exhibit 15. Doesn't that also say Rollins' phone or Rollins' house in the left?
It does.
Thank you, Your Honor. No further questions.
Alrighty, any redirect?
Yes, Your Honor, but before I begin, can I inquire the court on a brief time check?
The prosecution has 15 minutes and 40 seconds remaining.
Detective, based on all the evidence that you gathered, who was your primary suspect?
As I've stated numerous times in my testimony today, it was Avery Becker.
And how likely is your investigation to be about Avery Becker?
Highly likely, as most of the evidence point towards him.
And how likely is it that Avery Becker broke into 444 South Flower Street?
It is highly likely, as due to the text conversation that Mr. Becker planned on breaking into and trashing Mr. Brackman's residence.
Thank you, Your Honor. I have no further questions.
Alrighty, any recross?
No, Your Honor.
Okay, Detective Markowitz, you may be excused.
Your Honor, at this time, the prosecution would like to call Kyle Kuzak to the stand.
Alrighty. Good morning, Mr. Kuzak.
Morning, Your Honor.
Please state your name and spell the last for the record.
My name is Kyle Kuzak. That's spelled K-U-Z-A-K.
And Mr. Kuzak, what is your employment?
I am a Colorado Bureau of Investigation certified crime scene reconstruction investigator, or if that's too much of a mouthful, CSR would suffice.
And how long have you been investigating crime scenes?
Let's see, I have 19 years of experience, with the most recent 3 being with the City of Denver.
Your Honor, pursuant to Rule 702, I would move to enter Kyle Kuzak in as an expert witness in crime scene reconstruction.
Defense?
No objections, Your Honor.
Okay, they'll be entered as an expert.
Mr. Kuzak, why are you here today?
I am here today to testify to my findings at the scene of the homicide of Mackenzie Brackman at 444 South Flower Street. I also conducted a 5-step methodology for this case.
Can you elaborate on that methodology?
Yes, I approach all of my CSR work in these 5 steps: hypothesis and reconstruction and documentation. Or, forgive me, I'm stumbling on my words. Excuse me. It is I'm sorry. Forgive me. It is recognition and documentation, hypothesis or collection of evidence, evaluation of evidence, hypothesis and reconstruction, as hypothesis and documentation as well as reconstruction.
And tell me about your documentation step.
I conducted a 5-step and I conducted a witness tracking spreadsheet. This witness tracking spreadsheet was used through all of the evidence and all of the events, as well as with regards to all suspects and witnesses.
And can you tell me more about your witness tracking spreadsheet?
Yes, I created this witness tracking spreadsheet through my own personal knowledge of the case, as well as the knowledge of my peers. This witness tracking spreadsheet was used as a way to summarize key points of information as well.
Your Honor, may I show the witness what has been marked as Exhibit 17?
Go ahead.
My co-counsel should be bringing it up. Mr. Cusack, what is this?
This is a copy of the witness tracking spreadsheet I created.
And is this a fair and accurate representation of that witness tracking spreadsheet?
Yes, it is.
Your Honor, I move to enter Exhibit 17 into evidence.
Any objections?
Your Honor, before I make my objection, I would request to know whether opposing counsel wishes to enter all of Exhibit 17, both of the spreadsheets and the flow chart, or is only going to be referring to just the witness tracking sheet.
Your Honor, I will only be referring to the first page of the witness tracking spreadsheet.
Yes, Your Honor, then I would object on solely the grounds of hearsay.
Okay, response, counsel.
Your Honor, under Rule 803-6, this is a regularly conducted activity, and I believe I've laid, or that through my witness's testimony, there has been sufficient foundation laid for this hearsay exception.
Okay, response, defense.
Yes, Your Honor. I believe that a regularly conducted activity is an activity that can be made quickly and easily, is fairly routine. In this case, Mr. Cusack is putting different things in these spreadsheets each time he is making them. Spreadsheets are going to look different for each case. He might not have a spreadsheet depending on the case. I don't believe this qualifies as a regularly conducted activity.
Your Honor, if I may, my witness testified to making one for every case, and making one for this case, testified to the information coming from coming from the evidence and events of the investigation, from his peers and his own knowledge. And I believe that I've sufficiently gone through the foundations that are needed to be laid for my hearsay rule.
Okay. The objection is well noted, but I'm going to overrule it and allow this evidence in. I do think this is a regularly conducted activity for his profession. So,
yes, Your Honor.
How did you create this witness tracking spreadsheet?
Well, this witness tracking spreadsheet was created through an organized listing of all the evidence, events, interview reports, and really any other bits of information that related to this case.
You mentioned interview reports, but with who?
These interview reports were with Avery Becker, Taylor Perkins, Brandon Digby, as well as Josiah Mitchell.
You mentioned Avery, but what did she say, or what did she bring up in her interview?
Well, during Avery's interview, she stated that she had a text exchange with Taylor Perkins on March 6th, the day of the murder, and Taylor Perkins supported this statement from Avery as well in her interview, forgive me.
Moving on.
Your Honor, I would object to 602 lack of foundation for that statement. These interviews were not interviews done by Kyle Cusack, but information given by the police. I don't believe there's been enough foundation laid for Mr. Cusack to testify to the contents of these interviews, especially seeing as there is no copy of the interview report included in this case, just a very brief summary.
A response, counsel.
Your Honor, I believe that my witness had testified to looking into all evidence and all case materials, including these interview reports, and he documented them what his findings into this witness tracking spreadsheet, along with his peers and colleagues' findings. So I believe he is able to testify on this facts.
Defense, I tend to agree. So what more foundation would you want laid in order to get this exhibit in?
I would like to have questions asked about the process of receiving these interview reports and talking with the police, seeing as Mr. Kuzak did not complete these interviews himself.
Okay, counsel, I think your objection goes more towards the weight of the testimony and not its admissibility. So if you want to bring it up on cross, I implore you to, but at this time, I'm going to overrule that objection.
Yes, Your Honor.
Yes, Your Honor. Moving forward, what were your next steps in the case?
Collection of evidence and evaluation of evidence. These next steps revolved around organizing all events as well as conducting analysis of them as well.
And what did you do next in the investigation, Mr. Kuzak?
Well, I did the analysis of the investigation and all of the evidence, as well as created a hypothesis. These analyses as well as hypothesis really help us understand what really went on during this investigation and what exactly happened on the day of March 6th.
And Mr. Kuzak, what was your final step?
My final step was in reconstruction, and this reconstruction has to do with going back to my initial interview reports, as well as my peer review from my colleagues, and creating a final reconstruction report on this case.
Yeah. Also, co-counsel, you can take down the exhibit. Sorry, I forgot to mention that. Do you normally have peers review your work, Mr. Kuzak?
Yes, it is very important to me that my work is to the utmost quality through my peers' critiques.
And what kind of conclusions did you come to after completing your methodology?
Well, after my entire methodology was completed, I had enough information to really figure out what happened. And what happened was the intruder went to the house, initially wanting to commit burglary, where an altercation unraveled between the intruder and the victim, leading to Mr. Brackman being stabbed in the upper left shoulder blade. The intruder left the scene, and Mr. Brackman bled out after removing the blade from the wound.
And finally, in your opinion, Mr. Kuzak, is this the only series of events that can explain what occurred on March 6th, 2020?
Yes, my information is based off of sufficient facts and data that I base them off the scientific method and scientific principles. This is the only possible really outcome for what happened at the scene of the crime.
No further questions at this time, Your Honor.
All right, any cross-examination?
Yes, Your Honor. May I proceed?
You may.
Good morning, Mr. Kuzak. I'd like to talk to you about your reconstruction of the crime scene. It involves a scuffle between the intruder and Mr. Brackman. Is that correct?
That's correct, yes.
And one of your supporting pieces of evidence for this scuffle are scuff marks on the floor. Is that right?
Yes, as well as a broken plate.
Yes. And you saw these scuff marks when you completed your reconstruction of the house. Is that right?
That's correct, yes.
You reviewed them thoroughly?
I did. I reviewed all of the evidence in this case thoroughly.
Would you recognize a photo of those scuff marks if they were shown to you?
Yes, I would.
Your Honor, may I have permission to show the witness what has been previously marked as defense as Exhibit 18?
You may.
Now, Mr. Kuzak, are these the same scuff marks that you saw on the day you completed your reconstruction?
Yes.
Is this a fair and accurate representation of those scuff marks?
Yes, it is.
Your Honor, I move to admit Exhibit 18 into evidence.
Any objections?
No objection, Your Honor.
All right, then they'll be admitted.
Your Honor, I move to publish to the jury.
They'll be published.
Thank you, Your Honor. Now, Mr. Kuzak, You can't say how old these scuff marks are, can you?
No, I cannot put a date on them, no.
And these scuff marks, they're by the door, is that right?
That's correct.
And they roughly, to the best of your ability to see, take the shape of parallel lines, is that right?
Yes, I would say so.
And I think you'd agree, not even as an expert, just as a lay witness, that most people walk with their feet in parallel lines, yeah?
Objection, Your Honor. Relevance.
Response, counsel?
Response. Yes, Your Honor. It's part of the prosecution's case that there was a scuffle involving the intruder and Mr. Brackman, as these scuff marks are one of only 2 pieces of evidence that point to this scuffle. It's part of the defense's case to disprove the theory of this scuffle, and I'm using the scuff marks in ways that they could have been formed to help our theory of the case.
Okay, I'm going to overrule that objection. Relevance is a low bar, and this seems pretty relevant. So,
Thank you, Your Honor. Now, Mr. Kuzak, just to re-ask that question, most people walk with their feet in parallel lines. Would you agree?
Yes, I would say so. Not everybody does a crab walk.
Yes, I would agree with that, Mr. Kuzak. And if you're dragging a piece of furniture, would you say that the legs would usually come down in parallel lines?
Yes, however, those look very close together to be the legs of something supporting a table or a chair.
Of course, Mr. Kuzak. And nowhere else in your report do you mention any other scuff marks.
No, I do not.
Thank you, Mr. Kuzak. Thank you, timekeeper. I'm done with this exhibit. Now, Mr. Kuzak, you also reviewed ring videos as a part of your investigation for this case.
Yes, I did.
You looked at them thoroughly.
Yes.
Would you recognize copies of these ring videos if they were shown to you?
I would, yes.
Your Honor, I ask permission to bring up what has been previously marked as defense's exhibits 10 and 11.
go ahead.
Thank you. Now, this is defense's exhibit 11, Mr. Kuzak. Do you recognize this video of Mr. Brackman, not Mr. Brackman, the intruder, coming through the back, not the back door, the side gate?
Yes, I do.
Would you say this is a fair and accurate copy of that exhibit?
I would say so, yes.
Your Honor, I move to admit exhibit 11 into evidence.
Any objection?
No objection, Your Honor.
All right, then it'll be admitted.
I move to publish to the jury.
It may be published.
Thank you, Your Honor. Now, if we could direct our attention to exhibit 10. Would you say this is a fair copy of the video you reviewed of the intruder coming to the front door, attempting to ring the doorbell or knock?
Yes, I would say so.
Your Honor, I move to admit exhibit 10 into evidence.
Objection, prosecution?
No objection, Your Honor.
Okay, then it'll be admitted also.
I move to publish.
It'll be published too.
Thank you, Your Honor. Now, if we could move back to exhibit 11, sorry, timekeeper, and thank you. Now, you in your testimony a minute ago mentioned just one intruder in the singular, is that correct?
That is correct, yes.
Now, if we could zoom in on the shoes of this intruder as best as we can through Zoom, I think you'd agree that we can see 5 little silver circlets on either side of each shoe. Is that correct?
I cannot see the other shoe. I can only see 5 circlets.
Sure, yes, on the shoe that's in front. And you can see laces on that shoe as well. Is that correct?
Yes.
Now, timekeeper, if we could move back to exhibit 10. And once the time is right, zoom in on the shoes. Now, I think you'd agree, Mr. Kuzak, that you cannot see any of those silver circlets on these shoes.
No, you cannot.
And you cannot see laces on these shoes.
I cannot.
And Mr. Kuzak, nowhere in your testimony do you mention this discrepancy.
No, I do not.
Thank you, Mr. Kuzak. Now, just one final thing regarding the videos. You believe that the knife came from inside the house. Is that correct?
Yes.
But you can't see underneath any of the intruder's clothing, right?
No, you cannot.
Thank you. Thank you, timekeeper. I'm done with this exhibit. Now, Mr. Kuzak, you also discussed a witness tracking sheet that you already talked about in your direct.
Yes, that's correct.
Your Honor, may I pull up previously admitted exhibit 17?
Certainly.
Now, Mr. Kuzak, nowhere on this exhibit does it say who conducted those interviews.
No, it does not.
And you heard Detective Markowitz testify earlier today, is that right?
Yes, I did.
And Detective Markowitz, nowhere in their testimony did they mention any other interviews other than that of the one with Alex Cifuentes.
That is correct.
And Mr. Kuzak, all of the dates, if you look under interview report, those dates are all in June, is that right?
Yes.
And this crime was committed on March 6th.
Yes, the crime was committed March 6th, yes.
Thank you, Mr. Kuzak. Just a few questions left. Now, you say that you would like more evidence for this case, is that right? Oh, and timekeeper, I'm done with exhibit 17. You say you would like more evidence to make your reconstruction for this case.
Yes, I would.
You didn't have any DNA data.
No.
You didn't have any fingerprint data.
No.
And you didn't have video from inside the house as this crime was being committed.
No, we do not.
Thank you, Mr. Kuzak. Thank you, Your Honor. I have no further questions.
All right, any redirect?
Yes, Your Honor, briefly, and I ask for a brief time check before I go.
Prosecution has 7 minutes and 56 seconds remaining.
Mr. Cusack, would you say that that the intruder looked the same in all 3 videos, or in all 2 videos that we're seeing today?
Yes, they were wearing the same mask and same outfit regarding shirt and pants.
And how probable would it be for 2 people to wear the exact same outfit and be committing the exact same crime at the same time?
I would say fairly probable, yes.
Fairly probable or fairly improbable? Sorry.
Oh, my apologies. Improbable.
And you mentioned DNA evidence. Do you need DNA evidence to find a suspect?
No, we have the height and build of the intruder, and that's actually very generous to have in a case.
No further questions at this time, Your Honor. And barring no recross, I ask that my witnesses be able to step down from the stand.
All right, any recross?
No recross, Your Honor.
All right, then Mr. Kuzak, you may be excused. Any other witnesses to call prosecution?
Yes, Your Honor. The prosecution calls Alex Cifuentes to the stand.
Okay. Good morning, Ms. Cifuentes.
Good morning.
Please state your name and spell it for the record.
Alex Cifuentes, Cifuentes, Sifuentes.
And Ms. Cifuentes, why are you here today?
I'm here because something really terrible happened to my mock trial coach, Mr. Brackman, and I'm just trying to aid by giving any info that could possibly help unmask the killer.
How were you introduced to mock trial?
My freshman year, Avery actually introduced me to the mock trial team, and since then, I've been pretty avid about it.
How do you know Avery Becker?
Well, like I said, we were on the same mock trial team, and me and Avery actually used to be really close. I would even go as far to say is that we were best friends at some point in time.
If I asked you to point out the defendant in the courtroom here today, could you?
Yes, I could.
Your Honor, I ask that Avery Becker turn on their camera to be identified.
Yeah, let's have all witnesses turn on their camera, just so that it's not just the defendant who comes on screen.
Would you please describe for me the defendant here today?
Well, as you can see, he's wearing a white shirt and a black jacket and what looks like a yellow tie.
And how do you know that that is him?
Well, we've been on the same mock trial team since my freshman year of high school, so I'm quite sure I know what Avery looks like.
Your Honor, let the record reflect that my witness has identified who is the defendant.
It'll correctly reflect that they have identified Mr. Becker, and everyone can turn off their videos now.
Has your relationship with Avery changed since freshman year?
I guess you could say that our relationship has become more strained in a sense. During our last season of competition, Avery had really unmasked his true character and did away with this facade that he had had. He had really lost the team player mentality that the rest of the team had and would show up to practice constantly late and would blatantly disrespect Mr. Brackman.
You mentioned that you don't think that Avery treated your coach with respect. Why is that?
Mr. Brackman was an amazing coach that really pushed every member of the team to reach their max potential, especially Avery. I really looked up to him.
And what effect did Avery's behavior have on the team?
Avery's behavior constantly left the team in a state of panic. He was never prepared, and this was something that Mr. Brackman constantly stressed, being properly prepared.
You mentioned that Mr. Brackman would reprimand him for his behavior. What effect did this have on the relationship between Avery and Mr. Brackman?
Avery hated Mr. Brackman for constantly getting on him about his work ethic. I would say that the two have always had bad blood.
There is no way that this witness, Alex Cifuentes, can know that Avery Becker for sure hated Coach Brackman. So this is speculation on their part.
All right, response.
Your Honor, my witness is testifying to her rationally based perception of what happens, and I believe at the beginning counselor was implying lacks of personal knowledge, to which my witness has been on the mock trial team with them and gone to school with all of these people for the last 3 years, and is now in her senior year of high school. I believe she would have sufficient knowledge, sufficient observation to observe this fact between the two.
Response, Your Honor.
Sure, yeah.
Your Honor, there is no way that Alex Fuentes can know for sure that Avery Becker hated. She's allowed to, yes, give her rationally based perception, but she cannot say that for sure Avery Becker hated Coach Brackman. So therefore, I still go on my original objection that it is still speculation.
Yeah, it's okay. I agree that she can testify to her rationally based perceptions and what she thought the relationship was like, but to generalize and say that it was a definitive thing, I think is a step too far. So let's just make sure the witness stays within those grounds. So I'm going to sustain that objection.
Would you like to finish your response?
Oh, I was done.
Okay. What would you say was this boiling point of Mr. Becker and Coach Brackman's relationship?
Well, so we had just gotten back from regionals and it was the practice following that regional competition, and Mr. Brackman had confronted Avery about his work ethic, and at the beginning of that practice, Avery had come in late and was at the end of that practice demoted to B team.
And what happened after Avery got demoted?
Well, Avery then convinced his friend Taylor Perkins to quit the team.
And after Perkins quit the team?
This then forced Mr. Brackman to have to move Avery back up to A team.
What happened after your regional competition?
So after our regional competition, sorry, I misspoke earlier. Mr. Brackman was really upset with Avery's work ethic, and he actually confronted Avery. And like I said, Avery was really upset and did something that I don't think anyone really would have expected.
What did he do?
Avery wrote on the hood of Mr. Brackman's car in permanent marker.
And how do you know this?
Well, Avery had admitted to it, and the whole team knew when Avery was kicked off of the team.
Objection. I would say lack of foundation. This witness has just testified that she was not there when Avery Becker supposedly wrote Worst Attorney Award on the car. so therefore she has no immediate personal knowledge that this actually happened.
Response.
Yes, Your Honor, my witness had just testified to saying that Avery had admitted it at that point. She would have known what happened on the team, and seeing as Avery then got demoted as well, I'm sure that the team would have found out what happened, especially with the coach being so upset and her being there. The witness never stated that she saw Avery write on the car. She says that she knew what happened.
Okay, final word, defense counsel.
Yes, Your Honor. I would again go with lack of foundation because she cannot fully testify and be sure that that actually happened. She only heard the rumors, and those rumors would be hearsay under court. So to build up a better foundation, maybe include that conversation so that we can get a better sense of how she learned about how this information came to be.
Okay. So I'm going to overrule your first objection. I do think they have the knowledge to testify to this, but prosecution, let's just get a little more foundation about how she knows where that this event occurred.
Oh, yes, Your Honor. Ms. Fuentes, when this incident occurred, what happened when the coach found out?
He had went outside and got quite upset, and like I said, demoted and kicked Avery off of the team.
Did this happen in front of your whole team?
No, not that I'm aware of.
What happened when what then happened after he found out?
Like I said, Avery was then kicked off of the team, which really put the rest of us in a tight spot because state was coming up soon and last minute substitutions can't be made, which is a rule for mock trial. But in the end, this was no longer a problem because state got canceled.
I'd now like to talk about the text messages between you and Avery Becker. Will you please reference Exhibit 14? In Your Honor, since we had opposing counsel's timekeeper pull that up for the last examination, can we have them do the same thing since we don't want to be providing them with the incorrect evidence that.
Sure, yeah, let's pause time while they pull it up just because I know that they weren't prepared to do this and neither were you guys, so.
Thank you. Are these the text?
Let's start the time again. That's all I was gonna say.
Are these the text messages between you and Avery?
Yes, they are.
And what was this conversation about?
Well, Avery had texted me about trying to convince Mr. Brackman to let him back onto the team. I then spoke to Mr. Brackman, but he didn't have any intention of putting Avery back on the team.
And what was Avery's response to this?
At this point, his intentions were clear and unmasked. I completely seen a side of him that I had never seen before or would have expected. Avery then said that if Mr. Brackman was upset about his car, just wait and see what I do to his house.
Objection, Your Honor. This is hearsay. My opposing counsel has just offered a statement that is out of court and is used to prove the truth of the matter asserted.
Response?
Your Honor, I believe that as this exhibit has been entered and she is testifying to the contents, it is a statement made by a party opponent as well. Avery Becker is who she is testifying to.
Yeah, I agree with the prosecution here. Overruled.
To clarify for the jury, could you please just repeat the end of your response as you were cut off?
Yes, Avery said that if Mr. Brackman was upset about what I did to his car, just wait and see what I do to his house.
Thank you, Your Honor. No further questions at this time.
All righty, any cross-examination?
Yes, Your Honor. May I proceed, Your Honor?
You may.
Thank you. Good morning, Ms. Fuentes.
Good morning.
Now, you went to Colorado High School,
Yes,
right? Yep. And you were on the mock trial team.
yes, I was because of Avery.
And Mackenzie Brackman was the coach of this team.
Yes, he was our coach.
Avery Becker was also on the mock trial team, right?
Yes, he was.
Now, you say you are basically best friends with Avery Becker.
Yes, at some point in time.
In fact, you credit Avery for helping convince you to join mock trial in the first place.
Yes.
But you don't mention hanging out with Avery outside of mock trial in your witness statement, do you?
No, not all friends hang out outside of school.
Right. You don't mention going over to Avery's house,
No, I do not.
nor do you mention Avery coming over to your house.
No, I do not.
But again, Avery Becker was basically your best friend.
At some point in time, yes.
Now, moving on, Avery eventually got kicked off the team for good, right?
Yes.
After he wrote Worst Attorney Award on Coach Brackman's car.
Yes, that's correct.
And after that incident, Avery texted you trying to get back onto the team.
Yes, he did, as we just saw.
And you later had an interview with a police detective regarding these text messages.
Yes, Detective Markowitz.
But you didn't bring your phone with the text messages on them to the interview.
No, I had accidentally left it at home that day.
Right. You left it on the charger at home.
Yes, that's correct.
Now, did Detective Markowitz ever come and get the phone?
No, Detective Markowitz did not. She said that sending in screenshots would be fine.
Did they ask for a follow-up interview regarding the phone?
No, I had actually offered to come in and bring the phone, but like I said, the Detective Markowitz said the screenshots would be fine.
Right. And later you got a new phone, correct?
Yes, I did.
And you have no idea where your old phone is now.
I do not.
But you did send the screenshots of the text messages to the police.
Yes, I did what was asked.
And the police, they accepted them?
Yes, they did.
Okay. Now, you say that Avery Becker contacted you and asked you to talk to Coach Brackman, right?
Correct.
And you later talked to Coach Brackman.
Yes, I did.
And then you later say that you sent a text message to Avery that you talked to Coach Brackman.
Yes.
And you texted Avery that Coach Brackman wouldn't budge and let Avery back onto the team.
Yes.
Your Honor, may I have permission for my timekeeper to pull up previously admitted Exhibit 14?
Absolutely.
Ms. Cifuentes, can you please show me on Exhibit 14 where you texted Avery and said that Brackman was not going to back down?
Not verbatim, but I do say that after the car situation, his mind cannot be changed.
Right, but you don't text Avery saying that you talked to Coach Brackman.
No, that's not in the text messages.
Right, and you also don't text Avery saying that Coach Brackman wouldn't budge.
No, that's not there.
But these are the real text messages, right?
Yes, they are.
Okay. Timekeeper, you can remove Exhibit 14 now. I'm done with that. Now, finally, Ms. Cifuentes, you were in possession of Avery Becker's cell phone on March 5th, right?
Correct.
Right, that was at the Fry Shack.
Yes, at the Fry Shack.
And this day, March 5th, this was the day before Avery's phone went missing.
Yes.
And this was also the day before Mackenzie Brackman's murder.
Yes, it was.
Thank you, Your Honor. I have no further questions.
Okay, any redirect?
Very briefly. Are these screenshots your accurate text with Avery Becker?
Yes, they are. I have no reason to lie.
Thank you, Your Honor. No further questions.
Okay, you may be excused, Miss Sifowitz, and Do you have any other witnesses to call today?
No, Your Honor, the prosecution rests its case in chief.
All righty. Let's give it a couple seconds for scores just to write everything down, and then we'll proceed on to the defense. Okay, defense, do we have any witnesses to call today?
Yes, Your Honor, the defense calls Avery Becker to the stand.
Good morning, Mr. Becker.
Good morning, Your Honor.
Good morning, Mr. Becker. Can you please introduce yourself to the jury?
Hello, my name is Avery Becker, and last year I was a senior at Colorado High School.
And what did you like to do at Colorado High School?
You know, I like doing what all high school kids love doing. I loved hanging out with my friends, and me and one of my best friends, actually Taylor, decided to do mock trial, which I love now too.
Could you tell us about your experience with mock trial?
Yeah, I mean, I loved it. It meant a lot to me, and I loved that I was able to hang out with Taylor as well.
Did you have any difficulties with mock trial?
You know, overall, I had a really amazing experience, but, you know, sometimes me and my coach, Mr. Brackman, didn't see eye to eye, and I wish that could have been different.
Other than that, did you like your team?
Yeah, I really liked my team. I mean, Mr. Brackman, I mean, despite our differences, he definitely made the team more competitive. And, you know, I love hanging out with Taylor, and she was on the team with me.
Did anything ever happen between you and Mr. Brackman?
Sadly, the tensions between us were high a lot of the time, and sometimes we'd get into arguments. Probably our biggest argument was just after regionals.
Oh, what happened?
Well, as I said, it was just after regionals, and I thought I had done really well. I had won best closer, and I had won best attorney too, and I was proud of myself. But Mr. Brackman seemed really angry at me, and he told me I didn't deserve my award, and I wasn't going to be any good at state. I rushed out of practice, and what I did next was the dumbest thing I've ever done.
What did you do?
Well, it was a complete accident, and I never should have done it, but I accidentally drew on his car. I thought it was a dry erase marker. I had been using dry erase markers in the practice, and I took it out to the car and I wrote on it. And when he found out, he kicked me off the team.
Did you intend to cause harm to Coach Brackman's car?
No, I of course not. I would never try and hurt Mr. Brackman in any way, and I just was trying to send a harmless message. I thought it was a dry erase marker, and it turned out to be a permanent marker.
And did you tell anyone about what happened?
Yeah, I talked to my mom about it afterwards, and she told me to do the right thing, which was obviously to apologize. And so I went to his office and tried to apologize in person, but he wouldn't see me. And so I texted him. I offered to get a job and try and pay for repairs. I tried to make it right, but he ignored me.
Thank you, Avery. I'd like to talk about the night before the accident. That was March 5th. Do you remember what you were doing that night?
Yeah, I was hanging out with my friend Taylor. we went to the Fry Shack, which is this amazing little place that all the CHS kids go. And we were playing on our phones, and the mock trial team in, and I got distracted, and then I went home.
How about the next day? What did you do?
Well, I must have left my phone somewhere the day before because I lost my phone. So I skipped school with Taylor and retraced my steps from the day previous, and I had Taylor call my phone a bunch and just trying to look for it the entire day.
So when did you hear about what happened to Mr. Brackman?
Well, I heard that something was wrong when we went to the Fry Shack. We were retracing my steps, and we ended back up at the Fry Shack, and the mock trial team was there again, and they said that Mr. Brackman had never shown up to practice, which was really weird.
Okay, can you clarify the statement for me, prosecution?
Your Honor, I believe that the witness just said that Mr. Brackman did not show up, and is saying when they learned of that information, it's being offered for the truth of the matter asserted to say when he did not show up.
Okay, response?
My witness just said that he's just stating facts from that night, and he's not quoting anything that Mr. Brackman or any other student said.
Okay, response, prosecution?
Your Honor, I have to disagree. I believe that he is stating exactly what these students were saying at the Fry Shack that night, and it's being offered for the truth of the matter asserted, and I move to strike that from the record.
Okay, final response, defense, to the claim that these statements are coming from the students.
But it is under one of the exceptions that it's not coming from any of the opposing, or sorry, I take that back. But Mr. Becker is just trying to say what happened that night and how he found out what happened to Mr. Brackman. I'm just trying to lay some foundation for the jury and for everyone here.
Okay, I'm gonna sustain that objection. It does seem like it's being used for the truth of the matter asserted. So if you can lay that foundation about what happened that night without getting into this hearsay, I think we should proceed in that route.
Your Honor, I move to strike any of testimony about the statement.
Sure, yeah.
May I re-ask the question and just give Mr. Becker a chance to reword himself?
Of course, yeah.
So when did you find out about what happened to Mr. Brackman?
Well, as I said, it was at the end of the day. We were retracing my steps, and we ended up back at the Fry Shack. And I learned that Coach had never shown up to practice, which was very surprising.
Thank you, Avery. Now I'd like to talk a little bit more about the allegations against you. Earlier in court, you heard Ms. Fuentes testify about the supposed text messages you sent her.
Yes.
Your Honor, admission to bring up previously admitted Exhibit 14.
Go ahead.
Do you recognize these texts?
No, I've never seen those before today. I definitely didn't send those. I would never do that. Me and Alex aren't exactly close.
So how would you describe your relationship with Alex?
Well, you know, me and Alex weren't exactly friends. We sort of just knew each other through mock trial. We were polite to one another.
Thank you, timekeeper. You may take those down now. And earlier in the trial, did you see the ring videos as well?
Yes.
Was that you in the ring videos?
No, of course it wasn't me. First off, I didn't even know where Mr. Brackman lived, and I definitely didn't want to hurt him. I wanted to apologize. I knew that I messed up, and I just wanted to say that I was sorry. I never would ever hurt Mr. Brackman.
And did you enter Mr. Brackman's house on March 6th?
No, once again, I didn't even know where he lived, and I never wanted to hurt him in any way. I would never do anything like this.
And lastly, if you were able to contact Mr. Brackman on March 6th, what would you have wanted to say to him?
Objection, Your Honor. Relevance and calls for narrative.
Okay, response.
I'll respond to the relevance first. It is relevant because it is under jury instruction number 8, and it is the witness testifying his state of mind at that time, and you don't know, you couldn't possibly know that it could be narrative at this moment.
Okay, response to the narrative question, prosecution.
Your Honor, we have no idea what exactly the witness is going to say. And since it's asking for a broad statement of what they might ask and what they might say, that could include anywhere from a few sentences to a long soliloquy as well, which we are not sure of whether that could occur or could not occur. And I asked, if we're going with the narrative, that this question be more specific.
Your response, Your Honor?
No need, defense counsel. So I do think it is relevant. Relevance is a low bar, of course. And also, I mean, this is direct examination. They're going to be open-ended questions. And I think it was pretty tailored to what the witness will say. So I'm going to overrule both objections.
Thank you, Your Honor. May I re-ask the question just for, okay. Now, Mr. Becker, if you're able to contact Mr. Brackman on March 6th, what would you have wanted to say to him?
I would have wanted to say, Mr. Brackman, I'm sorry. I'm sorry for being a bad mock trial student. I'm sorry for what I did to your car. I wish everything could have been different.
Thank you, Your Honor. No further questions.
All right, any cross-examination?
Yes, Your Honor. Now, Mr. Becker, you were on the Colorado High School mock trial team for 4 years, right?
Yes.
And Mr. Mackenzie Brockman was the coach of that team.
Yeah.
Where you often got into arguments.
Sadly, yes.
Where he would call you lazy.
He would.
That your work ethic was terrible.
Yeah.
And this led you to say that he had a massive ego.
I thought so at times, yeah.
Even to go to lengths to call him a joke.
At some points I did, yeah.
No, Mr. Becker, you have an ego yourself as well.
I think everyone has an ego, yeah.
And this clash of egos often led to numerous arguments.
Yeah.
Even so much to get you demoted from your 18 position.
It did.
But then later on, your best friend, Taylor Perkins, quit the team for you.
It was very nice of her, yes.
And you knew she would quit for you.
Well, she didn't much like mock trial.
You knew you would get what you wanted.
I didn't know that she was going to quit the team. I hoped she would.
In fact, you like to get what you want.
I mean, everyone likes to get what they want.
You even wanted to win the Best Attorney Award at your regional tournament.
Yeah.
Going as far to say that you could spin a jury like a ball of yarn.
If I wish to.
And hold them like putty.
Yeah.
And you want to spin this jury like a ball of yarn.
No, I want to tell the truth.
And hold them like putty.
As I said, I don't know what you mean.
To get the outcome that you want.
Yeah, I hope I get the outcome I want. I would never do something like this.
I'd like to move on to March 6th of 2020. That is that you realized that morning that you had lost your cell phone.
Yeah.
That you had lost the day prior.
Yeah.
And you were present here when Mr. Kyle Kuzak testified under oath today.
I was.
You mentioned that you had an interview with the police.
Right.
Where you stated you had a text conversation with your best friend, Taylor Perkins.
That's not in my witness statement. Would you like me to respond?
No, but I'm mainly saying that you heard Kyle Kuzak testify to an interview that you texted Taylor Perkins. Not from your affidavit, but coming from Kyle Kuzak.
Yes, yes, I did hear that.
Where that conversation occurred on March 6th, according to Kyle Kuzak.
I don't remember if he said that or not.
Yet you claim to have lost your phone on March 5th.
I did lose my phone on March 5th.
And on March 5th, you and Taylor Perkins both skipped school that day.
Yeah, we were looking for my phone, which I lost.
Which you went to look at the mall in the Fry Shack, right?
Yeah.
Yeah, Taylor Perkins is your best friend.
Yeah.
Who would do anything for you.
I don't know about anything, but...
Including quit the mock trial team.
She did.
Now, I'd like to move on to the incident that happened with Mackenzie Brockman's Porsche. You on direct examination said that you accidentally rode on his Porsche, right?
Yeah, it was... I didn't mean to ruin his Porsche.
Yet you purposely wrote on the Porsche.
I didn't mean to destroy it. That was a complete accident.
But you still made the choice to write on the car.
I was caught up in the moment, yes.
Because you were angry.
At the time I was.
That you didn't get what you wanted.
I was angry because he had embarrassed me in front of the entire team.
And that made you even angrier. To be insulted.
Yeah.
And later that night, you went to talk to your mother about what happened that
day. I did.
But in that conversation, you never mentioned what you did to his Porsche.
I did not, no.
And in that conversation, Mr. Becker, you told your mother, and I quote, "I will get back at him if it's the last thing I did." Is that your statement?
It was in the moment. I felt differently when I was trying to apologize, obviously.
Thank you, Your Honor. I have no further questions.
All right, any redirect?
No redirect, Your Honor.
Okay, Mr. Becker, you may be excused. Do we have any other witnesses, defense?
Yes, Your Honor. The defense calls Taylor Perkins to the stand.
Ms. Perkins?
May I proceed, Your Honor? Oh, sorry.
Yes, you may proceed.
Thank you, Your Honor. Good morning, Ms. Perkins.
Good morning.
Can you please tell the jury about yourself?
Yes, I can. My name is Taylor Perkins. I'm currently a freshman at CU Boulder, but last year I attended Colorado High School.
Now, Ms. Perkins, did you participate in any activities in high school?
Yes, I did actually. While in high school, I was a part of the mock trial team.
Who was the coach of this team?
It was Mackenzie Brackman.
How was your experience on the mock trial team?
Well, initially it was good, but then it became a bit more awkward. Avery and Coach Brackman didn't always get along and they didn't see eye to eye.
What happened?
Well, they had very different teaching styles. Avery was more spontaneous. He was really good at improvising, but Coach Brackman was really about following the script and being more prepared.
Yeah, so what happened regarding their relationship?
It only deteriorated.
Were there any specific times where it deteriorated?
Yeah, at one practice before regionals, 1 month before regionals, Avery showed up the most unprepared he had, and Coach Brackman got really upset with him, and he demoted him to B team.
Now, how did you perceive Avery react to this demotion?
Well, Avery seemed really upset. I mean, it was his senior year, and he had put in the work for 4 years.
What were your thoughts on Avery's demotion?
I thought it was really unfair. I mean, I knew how much it meant to Avery, but not only that, I said that I didn't think we'd be able to make it to regionals without Avery.
So did you do anything?
Yes, I did. I actually decided to step down from the team.
Now, what were the effects on these two changes to the composition of the mock trial A team?
Yeah, well, once I decided to step down from the team, Coach Brackman let Avery back onto the A team.
So what did this mean for the team at regionals?
Well, we did really well at regionals, and Avery actually won 2 awards.
Now, did these awards in any way affect Avery's dealings with Coach Brackman?
Yes, they did. Unfortunately, it wasn't anything like you'd expect. I would have expected Coach Brackman to be proud, but instead, out of practice after regionals, he told Avery that he didn't deserve any of his
Your Honor,
awards.
say.
Okay, response, counsel.
Sorry, I didn't hear the objection. I kind of cut out for a second. May I ask what the objection was again?
Sure, counsel, can you clarify that objection?
Your Honor, I objected to hearsay.
Yes, Your Honor, on which statement, may I ask as well?
I believe that the witness was going to start speaking. She said Mr. Brackman told Avery, and I believe that this goes to the truth of the matter asserted, and the relationship between Avery Becker and, Mr. Brackman.
Okay.
Response?
Your Honor, this is not hearsay because we are not using it to prove the truth of the matter asserted. My witness was just going to talk about the conversation between the two of them at the practice. We weren't going to use what Coach Brackman said literally, so we are using it for the effect on the listener. Therefore, it is not hearsay because we are not using it for the truth of the matter asserted.
Your Honor.
Okay, response?
Yes, Your Honor. I believe that this is for the truth of the matter asserted because this is going towards the relationship between Avery Becker and Mr. Brackman, and this is a sole part of the case that the defense is here with, this is a key part of the case. I believe that this is the truth of the matter.
Response.
Okay. No, I'm going to allow the statement in for the purposes of the listener's response. Okay, so response on the listener, which means I'm going to give a limiting instruction to the jury that it shouldn't be taken for its truth value. So counsel, please do bring out that effect on the listener through this testimony. And if they don't, counsel, you can re-raise your objection if you feel.
Yes, Your Honor.
Your Honor, may I re-ask the question? Ms. Perkins, how did this affect Avery's dealings with Coach Brackman?
Well, it only got worse at that practice after regionals. Instead of telling him how proud he was or that he had done a good job, Coach Brackman told Avery that he didn't deserve any of his awards, and he actually told him some other pretty mean stuff.
Now, how did Avery respond to this criticism?
Well, Avery got really upset after that. I mean, he was proud of himself, and so unfortunately, on his way out, he grabbed what he thought was a dry erase marker and he wrote on Coach Brackman's car.
Yep. So what happened next?
Well, after that, Avery tried to apologize. He tried to talk to Coach Brackman, but he was kicked off the team.
Did Avery ever try to get back onto the team?
Yes, he did. He reached out to a lot of our teammates to ask if they could talk to Coach Brackman and see if he could get back on the team. He even tried going into practice one day to apologize, but Coach Brackman asked him to leave.
What happened after Avery was asked to leave?
Well, after that, he came to my house and we were playing some games at my house, and we later went to have dinner at the Fry Shack.
What was that dynamic like at the Fry Shack?
At first it was good, but then it became uncomfortable because as we were finishing up dinner, the rest of the mock trial team came in. And I mean, Avery felt terrible. He really cared about mock trial, and seeing them all come in seemed to upset him more. And so he stormed off to the bathroom.
So what happened after he stormed off to the bathroom?
Well, when he left to the bathroom, he left his phone behind on the table. And at that moment, me and Alex were talking at our table.
When did you realize that Avery lost his phone?
We didn't realize until the next morning.
So what did you guys do?
I suggested that we should go look for his phone, so we retraced our steps and we were looking for his phone that day.
Did you ever find his phone?
Unfortunately, we did not.
How long did you search?
We searched all day long.
And was Avery with you the entire time?
Yes, he was.
All right. So please describe to the jury your interview with the police to discuss Mr. Brackman's death.
I did not have an interview with the police.
How many times did the police call you to set up an interview?
Once again, they did not.
Again, how many times did the police email you to set up an interview?
I didn't receive any emails from the police.
So, to the best of your knowledge, did the police learn about your activities to track down Avery's lost phone?
I don't know how they could have.
To the best of your knowledge, did they learn that you'd spent this time with Avery on the day that Coach Brackman died?
No, they did not.
Thank you, Your Honor. I have no further questions.
All righty, thank you. Is there any cross-examination?
Yes, Your Honor. Mrs. Perkins, you're best friends with with Avery Becker,
Yes, I am.
and you would do a lot for him.
Sure, I mean, anything a friend would do.
Moving to March 5th, the day before the murder, you guys had went to the Fry Shack, correct?
Yes, we did go to the Fry Shack for dinner.
And you saw everyone from mock trial,
Yes, the team showed up after their practice.
even Alex Cifuentes.
Yes.
And after Avery stormed off, you were left with Alex Cifuentes.
Yes, him and I were talking at the table where Avery had left his phone behind.
And you would even admit that you wanted to punch Alex in the face.
In the moment, I did say that because he just has a way of being very dishonest, and I could tell that he didn't really feel bad for Avery.
So that's a yes.
Yes, I did say that.
And once Avery came back, you guys left.
Yes, we did.
And you believe that Avery left her phone at the Fry Shack?
Well, I don't remember him taking it after leaving it on the table.
And you refer to Avery Becker's phone as his third kidney.
Yes, I did.
So he left his third kidney on a table, or that's what you believe.
Well, I think that just goes to show how upset he was.
Moving to the events of March 6th, you were picked up by Avery.
Yes, he did pass by to pick me up that morning. We usually carpool to school.
And when Avery woke up, he realized he didn't have his phone.
Well, actually, we realized when we were together when he picked me up.
Were you here for Avery Becker's testimony?
Yes, I was.
And on Avery Becker's testimony, did you hear him testify that when he woke up, he knew his phone was not with him?
I can't quite remember.
Moving on, were you present for Kyle Kuzak's testimony here today?
Yes, I was.
And did you hear him testify about an interview?
Yes, I did.
An interview that Avery had,
Yes, I did.
where he described a text exchange on March 6th.
I did hear something about that today.
And did you also hear Kyle Kuzak testify to the fact of your interview?
Yes, I did.
And he testified that in your interview, you corroborated the story of the text messages.
Yes, however, I never had an interview with the police. I believe Kyle Kuzak is not a part of the police department.
And the same day, or that March 6th is the same day you guys were looking for Avery's phone.
Yes, it was. And on March 6th, as we were looking for his phone, I called his phone several times. I texted it to hear it ring and try to find it.
But wouldn't you agree that an exchange is sending back and forth?
Yes, of course.
No further questions at this time, Your Honor.
Okay, any or redirect?
No redirect, Your Honor.
Alrighty then, Ms. Perkins, you may be excused. Do we have any other witnesses to call today, defense?
Yes, Your Honor. The prosecution calls Professor Blake Van Owen to the stand.
Good morning, Miss Owen.
Morning.
May I proceed, Your Honor?
You may.
Good morning, or maybe afternoon, depending on where you are and how you feel, Professor Van Owen. Would you please introduce yourself to the court?
Yes, of course. Good morning. My name is Professor Blake Van Owen, and I teach and study criminal justice.
How did you find yourself working in this area of criminal justice?
I always felt drawn towards criminal justice. I've always wanted to make a positive impact into my community, so I became a police officer. But I left the force after about 9 months because I realized that there were multiple practices with which I disagreed, and it was just something I couldn't allow myself to be a part of anymore. So I guess I left to pursue a career that felt more like I was actually helping people.
And what sort of things did you pursue to that end?
I worked a few jobs after that. First as a school resource officer, I went into private security, but then I began teaching classes on police practices.
That's lovely, Professor. Did you continue teaching or get any other work done since then? What has your life looked like?
I have continued to teach, but I've also gone back to school and I've received my master's in criminal justice. And I've also begun working as a private investigator, where for cases like these, I'll testify as an expert.
And what areas have you testified in before as an expert?
I've testified regularly as an expert in crime scene private investigation, cell tower data analysis, and general police practices.
Have you testified in crime scene reconstruction as well?
Oh, sorry, yes, I must have misspoke. I meant crime scene reconstruction. My bad.
Yes, thank you, Professor. And when you say regularly, what do you mean by that?
Well, I've testified in all these areas more than 5 times and in multiple states. I believe Colorado, Wyoming, New Mexico, Nebraska, and Arizona.
Thank you, Professor. That's a lot of states. And just briefly, you mentioned cell tower analysis. Do you describe anything about how cell towers work in your testimony, your witness statement, and your report?
I do mention in my expert report, I talk about cell towers and how your phones connect to cell towers.
Objection, Your Honor. Improper expert testimony, as this expert has not been testified or has been entered yet as an expert witness and is testifying to what they're testifying, what is written in their expert exhibit, which also has not been entered into evidence. So,
may I respond, Your Honor?
Yes.
Your Honor, to enter Professor Van Owen as an expert, we need to lay adequate foundation for the jury to understand her expertise. We don't, and if I may tender an offer of proof.
Sure, yeah.
We don't, Miss Van Owen does not intend to speak to any of the specifics of this case or even super specifics of cell towers themselves until she has been tendered as an expert, but we do need to lay some foundation. And if counsel finds that any of the other statements that Professor Van Owen will give in just a minute are too direct to this case, we could hopefully rephrase or give testimony in a slightly different way.
Yeah, I tend to agree with defense counsel. I think they're just laying the foundation. But if you have problem with how they enter it, counsel, feel free to re-raise if you feel like they're getting into those specific conclusions.
Now, Professor Van Owen, would you just restate just a little bit of what you say in your report?
I also talk about the mathematics behind cell towers a bit.
And would you say just a very brief bit about these mathematics?
Yes, well, I'd mention how to find the area in which these cell towers cover. And to find that, you take the radius of the coveraged area by the tower and you put it into the equation. It's really a lot like what you would see in an algebra course, the equation pi r squared. And to find the area of one of the 3 sectors of the tower, you would divide it by 3.
Thank you, Professor. I'm glad you can do math. Some of us struggle. Now, Your Honor, I would move to admit Professor Van Owen as an expert in 3 fields: crime scene reconstruction, cell site analysis, and general police practices.
Okay, any response, defense?
I have no objections at this time. I just ask that this witness stay within the scope of these 3 fields that she's being entered as an expert in during her testimony.
All right, then Ms. Owens will be entered as an expert.
Thank you, Your Honor. Now, Professor Van Owen, I'd like to start broad. What is the biggest takeaway you have from your time spent looking at the investigation done on this case?
Yes, to put it simply, this was a rushed investigation that was filled with mistakes, and that I believe that the police chose their suspect before they even really started investigating.
And would you elaborate on that last statement?
Yes, for starters, the first place that the police looked into was the high school mock trial team, where they heard from Alex Cifuentes about Avery Becker. And from this point on, they didn't look into any other suspects. So they essentially conducted this investigation with only Mr. Becker in mind.
Thank you, Professor. Now, you mentioned some other conclusions about the investigation being rushed and filled with mistakes in your words. What other parts of Detective Markowitz's investigation led you to these conclusions?
Well, you've already heard from the prosecution about these text messages that supposedly show Mr. Becker's intent to break into Mr. Brackman's home. But it's my opinion that you were misled as to the legitimacy of these text messages.
Would you explain more? What is your opinion on the legitimacy of these text messages?
Well, these text messages were actually screenshots sent to the police department by Alex Cifuentes. Now, the police could have authenticated these text messages to see if they were accurate. They have this special software called Celebrite, which pulls all the data off of a phone, and they can authenticate it that way. But Detective Markowitz chose not to do this.
Thank you, Professor. Now, I'd like to talk about another part of the police's investigation, the cell site analysis done by Detective Markowitz. What are your thoughts on this part of their investigation?
Well, again, you were presented with cell site data, but I think you were misled as to how cell towers actually work. The prosecution looked at this data and said if Mr. Becker's phone connected to these towers, then obviously the phone was there, and obviously Mr. Becker was there along with it. However, that's just simply not how cell towers work.
So, Professor, how do cell towers work? What's your opinion on the accuracy of this cell site data?
Well, you could be standing right next to a cell tower and your phone still connects to 1 mile away, because your phone isn't designed to connect you to the closest tower, but instead to the one that will give you the best signal. So just because Mr. Becker's phone pinged along these towers, it certainly doesn't mean his phone was there, and it certainly doesn't mean Mr. Becker was there.
What do you mean by it? It certainly doesn't mean Mr. Becker was there.
Well, you've already heard from both Mr. Becker and Ms. Taylor Perkins about how Avery had lost his phone the previous day and that they were looking for it. I mean, anybody could have had it, and that route the phone supposedly went along is a major walking route comprised of several major roads, whose sole purpose aren't only to get to Mr. Brackman's home.
Thank you, Professor. Just before I move on, was there anything else that struck you as poorly executed about this cell site investigation?
Well, Detective Markowitz could have attempted to verify Mr. Becker's alibi by pulling the cell site data records from Ms. Taylor Perkins' phone to see if the towers that her phone connected to generally match the locations that they described to going that day. But again, he chose not to. In fact, the only cell site data he pulled was from Mr. Becker's phone.
Thank you, Professor Van Owen. Now, I'd like to move on to a different part of the prosecution's case, the crime scene reconstruction done by Mr. Kyle Kuzak. Will you tell us your opinion on Mr. Kuzak's reconstruction?
In their investigation, Mr. Kuzak came to a lot of unsupported assumptions. For example, Kuzak opines that the scuff marks found on the kitchen floor are somehow indications of a struggle, but there's no way to prove this. Their story also hinges on Mr. Brackman both having heard Ring doorbell notifications and having grabbed a knife in self-defense. But again, there's no way to prove this.
And Professor, I mean, as someone who has completed some crime scene reconstructions yourself and has for sure looked over many a crime scene reconstruction, you know that making assumptions is sometimes a part of the job. Why is it that these assumptions were so particularly troubling to you?
Well, the assumptions made by Mr. Kuzak didn't seem to fit with much of the physical evidence, but instead seemed to match remarkably well with what Detective Markowitz described happening at the scene. I'm just troubled by how this reconstruction wasn't completed solely off of evidence, but seemingly with this secondary purpose to make it to match with the prosecution's version of events.
Thank you, Professor. You also completed your own sort of reconstruction for this scene. Is there anything you'd like to tell us about that?
I actually don't think that my own reconstruction is all that important to this case, because I don't think it matters the exact way in which Mr. Brackman was stabbed, because it's my opinion that Mr. Becker wasn't at the scene of the crime at all. And furthermore, I think the thing to focus on here is that Mr. Kuzak's investigation was filled with assumptions, and that we have no certainty that their conclusions even led to Mr. Becker.
Thank you, Professor. On the subject of your own conclusions, I'd like to return to the point you made about how the prosecution never looked into any suspects really other than Avery. Did you investigate other suspects where they did not?
Well, I can't point to anybody with 100% certainty, but I'm sure that there were multiple other people at least worth looking into.
And what do you mean by that?
Well, as a defense attorney, it's likely that Mr. Brackman would have had many disgruntled clients or families of clients, in particular a student named Blair Rollins, who went to the same high school as Avery and Taylor and was in fact missing the same day as them from school.
Would you tell us a little more about Blair Rollins?
Well, Mr. Brackman worked as a defense attorney for their father, and he ended up convicted by the jury. I believe he got sentenced to life in prison. And I can't tell you if Blair Rollins committed this crime, but I think that there's just as much cause, if not more so, to look into Blair Rollins, yet the police never even considered them an option.
Thank you, Professor. Finally, you've been present in court today for all of the testimony. Has there been anything presented today that would lead you to believe that Avery Becker was in fact at the scene of the crime on March 6th of 2020?
Absolutely not. I can't tell you who did it, but what I can tell you is that the only physical evidence that the police were able to find that could possibly point to Mr. Becker as the intruder was misleading cell site data from a phone that Mr. Becker didn't even have, and highly questionable, unauthenticated screenshots of a text message conversation we can't be sure ever actually happened.
Thank you, Professor. Thank you, Your Honor. No further questions at this time.
Thank you. Any cross-examination?
Yes, Your Honor. Professor Van Owen, you reviewed the evidence in this case.
Yes, I did.
And found it to be incomplete, correct?
Yes.
Then you conducted a partial investigation of your own.
Yes, I did.
In this investigation, you state that Alex Cifuentes was at school the day of March 6th.
Yes, I believe that he was.
But Avery Becker was not.
No, I checked the records and neither Avery Becker, Taylor Perkins, or Blair Rollins were at school that day.
Moving back to your concerns in the case. One of your concerns in the prosecution's case was that they didn't complete a thorough cell phone tower investigation.
No, they only pulled cell site data from a 35-minute window of one person's phone.
But in your partial investigation, you didn't include a complete cell phone tower investigation, did you?
No, but that was not my responsibility. My responsibility is to look at the police's investigation.
Well, but isn't it really true that the reason you didn't do it was because it led to Avery's guilt?
No, I didn't. No.
One of your concerns in the prosecution's case was that they didn't subpoena Alex Cifuentes' cell phone.
No, they never did. They never even attempted to get Alex Cifuentes' cell phone.
But your partial investigation didn't subpoena the cell phone either, did it?
I'm a private investigator. I don't have the authority to subpoena somebody's cell phone.
And one of your concerns in the prosecution's case was that they didn't thoroughly investigate Blair Rollins.
No, they never even looked into Blair. Not at all.
But your partial investigation didn't turn up Blair Rollins either.
No, Blair Rollins has, I believe, left the state. It would be really hard to find them.
And in your own partial investigation, you didn't confirm Avery and Taylor Perkins' whereabouts on March 6th of 2020.
Avery and Taylor both confirmed their whereabouts. They were out looking for Avery's phone.
But you never confirmed it yourself.
They confirmed it to me, yeah.
You didn't go to the mall to confirm if people saw them there?
No, but I would like to point out that that is not my responsibility. That is the responsibility of Detective Markowitz and the police department to do that.
So it's not your job to do a thorough investigation?
Are you somehow... My responsibility is to look over the police's investigation and to make sure that it was done thoroughly and without missing anything. And
And wouldn't you say that confirming where two suspects were the day of a murder is a thorough investigation? That is your job?
That's the police's job. That's Detective Markowitz's job.
But if you had found due evidence to believe that their investigation was not sufficient, isn't that what you were being hired to do?
I'm sorry, can you repeat that question?
If you're saying that that's not your job, that's the police's job. But wouldn't it be true that you were hired to look over the police's investigation?
Yes, it is.
So not completing a thorough investigation isn't your job.
My responsibility isn't to find the murder of Mr. Brackman. My responsibility is to look over the police's investigation to make sure that they have found the killer of Mr. Brackman.
You never confirmed where Taylor and Avery Perkins were.
Your Honor, objection asked and answered.
I'll allow this one question, but let's move on from this point afterwards, counsel.
You never confirmed their whereabouts?
Both Avery and Taylor confirmed them for me.
You didn't go to the Fry Shack to confirm their whereabouts?
No.
I have just a few more questions about your partial investigation. During your direct, you offered up Blair Rollins as an alternate suspect.
Yes, I pointed out that Blair Rollins is another student at Colorado High School who has, I believe, would have had, there's just as much cause, if not more so, to look into Blair, and I believe that it's troubling that the police never even looked into them at all.
So you made a determination that Blair Rollins had more of a motive?
I believe that your father being sentenced to life in prison is a more reasonable motive to look into than being kicked off of a high school mock trial team.
That determination is based on a statement that Blair Rollins' dad made at the end of a trial, correct?
Yes, if you listen to that court recording, it's kind of chilling what he says.
And that statement in that recording is, "I'll get you back, Brackman, if it is the last thing I do."
Yes, it is.
And you believe that this statement by Jonathan Rollins, Blair's father, is evidence of Blair's motive to kill Mr. Brackman?
I don't think it's evidence. I believe it's reason to look into Blair.
And that same statement is made by Avery Becker to his mother, is also evidence of Avery's motive to vandalize Mr. Brackman's home.
I believe that the context in which those statements are made are much different. One is a high schooler who has been kicked off of a high school team, and another is a man being sentenced to life in prison.
Is that a yes or a no?
They both said the same things, but that's what you're asking me, counsel.
Thank you, Your Honor. No further questions.
Thank you. Any redirect?
Your Honor, before I would do a brief redirect, if I could inquire as to how much time the defense has left for direct examination. "31 seconds left. All right, Professor, let's make this very brief. What is your job and how does it differ from the police's?
As my responsibility is not to find the murderer of Mr. Brackman. My responsibility is to make sure that the police have done an adequate job investigating this crime. My my response, I am not tasked with looking at the whole range of people in the world and saying, I think this person killed Mr. Brackman. My responsibility is to make sure that the police did that adequately.
Thank you, Professor. Thank you, Your Honor. No further questions.
All righty. Any recross?
No, Your Honor.
Okay, then Ms. Owen, you may step down. And do we have any witnesses left to call defense?
No, Your Honor. The defense rests.
Okay, let's take about 10, 15 seconds so they can get all the scores, then we'll move on to closing arguments. All righty, prosecution, do we have a closing argument for today's case?
Yes, Your Honor, and I'd just like to ask the court that we have adequately reserved time for rebuttal following my closing argument.
Yes, you all have.
Thank you. Your Honor, opposing counsel and members of the jury, this case has become undone, unraveled, and unmasked. Today, you heard from 6 witnesses testifying about what happened on March 6, 2020 at 444 South Flower Street, where Mackenzie Brockman's home was burglarized in an attempt to vandalize the property. However, Mackenzie Brockman was stabbed in the back because of Avery Becker. You saw Avery Becker's plan become undone and watched his facade become undone, as you've heard from Alex Cifuentes and Avery Becker himself. You heard from Alex Cifuentes testify about text messages and the bad blood between Avery Becker and Mackenzie Brockman. Looking at Exhibit 14, you can see Avery Becker clearly state that I am going to go to his house to trash it. Ladies and gentlemen, that is intent. Avery Becker knew what he was going to do, and that was going to 444 South Flower Street to vandalize his property. You heard that Avery Becker was upset at Mackenzie Brockman because he did not get what he wanted, because he liked to get what he wanted. And that caused him to be angry, causing him to say to his own mother, I will get back at him if it's the last thing I do. You just heard from Professor Blake Van Owen, who testified about an alternate suspect basing her sole opinion on a statement Jonathan Rollins made. And that statement is the exact statement the defendant has said in court today, that he would get back at Mackenzie Brockman if it's the last thing he did. Now let's look how we unravel what happened at 444 South Flower Street. You heard from Detective Jordan Markowitz with exhibit number 15, the call detail records that show Avery Becker's cell phone going from his house at the top of the map on exhibit 15, traveling down Rock Creek Parkway and arriving at 444 South Flower Street. And from 1:05 to 1:17 p.m., Avery Becker committed his crime, causing a scuffle between Avery Becker and Mackenzie Brockman, ultimately, but tragically, resulting in the death of Mackenzie Brockman. Avery Becker was caught unaware that Mackenzie Brockman was home, and ultimately had to get into a scuffle. Now, ladies and gentlemen of the jury, you heard the witnesses unmask Avery Becker. You saw Alex Cifuentes unmask Avery Becker by identifying him in the courtroom today. You saw Taylor Perkins identify Avery Becker with his rash and reckless decisions. And you heard Avery Becker testify himself that he would get back at Mackenzie Brockman if it was the last thing he did. And ladies and gentlemen, that's what he did. That on March 6th, he went to Mackenzie Brockman's residence. Now, the defense has come here today to say that the prosecution's investigation was rushed or reckless. However, the defense's case is full of so many inconsistencies that you can question that their case was rushed and reckless. Avery Becker and Taylor Perkins don't even agree on when the phone was lost, let alone whether they were in possession of it or not, as you heard from Kyle Cusack. You also heard Professor Blake Van Owen realize that she's being paid to give an opinion in which she did not even perform a thorough investigation that she was paid to complete. Ladies and gentlemen of the jury, as the prosecution, we bear the burden of proving to you beyond a reasonable doubt that Avery Becker is guilty of first-degree murder and second-degree burglary of all of the charges. And ladies and gentlemen of the jury, we have done that by undoing Avery Becker's facade and plan, by unraveling what happened at 444 South Flower Street, and by unmasking Avery Becker in the courtroom today. Ladies and gentlemen of the jury, I ask you, and based on the evidence, to convict Avery Becker. Thank you.
Thank you. All time will be reserved. Defense, do we have a closing statement?
Yes, Your Honor. May I proceed?
You may.
Rushed, reckless, guilty until proven innocent. Members of the jury, in their frantic stampede to condemn a suspect, Detective Markowitz's investigation became rushed, reckless, and filled with mistakes. The police decided Avery Becker was guilty until proven innocent and not the other way around. They only ever had one real suspect, only ever used one interview, relied on faulty cell site data and faulty text messages, and yet were determined to convict a high school boy. Members of the jury, today we have shown you that the prosecution's case is little more than holes, mistakes, and assumptions strung together by pieces of broken narrative. Now, the prosecution has the burden of proof today. Pursuant to jury instructions 8 and 9, they must prove to you, beyond a reasonable doubt, that on March 6th of 2020, Avery Becker committed second-degree burglary by knowingly and unlawfully entering the residence at 444 South Flower Street on March 6th of 2020. And in doing so, committed criminal mischief. And pursuant to jury instruction number 7, they must prove to you beyond any reasonable doubt that in course of or in furtherance of a second-degree burglary committed by Avery Becker, Mackenzie Brackman was killed. And jury instruction number 2 tells you that if you find that any of the elements of either of these crimes has not been proven beyond any reasonable doubt, you must find Avery Becker not guilty. Now, all the elements the prosecution must prove today are contingent upon one thing, that Avery Becker was in fact at 444 South Flower Street on March 6th of 2020. The prosecution showed you cell site data to attempt to prove this fact, and all they really proved was a police force rushing their investigation and jumping to conclusions. Professor Van Owen told you that cell site data cannot definitively show the location of a phone, and you heard Detective Markowitz admit on cross-examination that she cannot be completely sure that Avery Becker was at Mr. Brackman's house on March 6th. And most importantly, you heard both Avery and Taylor testify that Avery wasn't in possession of his phone on March 6th. He was looking for it, as he had lost it the night before. Anyone could have picked up Avery's lost phone. Anyone could have used it. And yet the prosecution wants you to believe beyond any reasonable doubt that both Avery and his phone were at the scene of the crime. But why stop there? The prosecution tried to show you that Avery had motive to break into Mr. Brackman's house pursuant to jury instruction number 8. They showed you text messages supposedly sent by Avery Becker to Alex Cifuentes. But members of the jury, these text messages were screenshots. And Professor Van Owen made you aware that Detective Markowitz never even attempted to verify them despite having the technology available to do so. And on the list goes. Detective Markowitz only ever interviewed Alex Cifuentes. Detective Markowitz never pulled any cell site data other than that of Avery Becker. You heard Detective Markowitz admit on cross that she didn't think it was important to investigate the alibi of her main suspect. And Detective Markowitz never had any other true suspects. Detective Markowitz never looked into Blair Rollins. But even putting all of that aside, members of the jury, the prosecution brought one more person before you today. Crime scene reconstructionist Kyle Kuzak. But Mr. Kuzak's reconstruction sports as many assumptions as the detective's investigation does mistakes. Mr. Kuzak assumed that the scuff marks were indications of a fight. He assumed that the knife came from the house. He told you he assumed that there was one intruder, despite the fact that in 2 different ring videos having elapsed over a matter of seconds, the intruder was seen wearing 2 different pairs of shoes. Members of the jury, assumptions, theories, and guesswork are simply not a basis for conviction. The prosecution would like you to believe that they've unmasked Avery Becker. But members of the jury, the devil mask on that intruder never came off, and there is no tangible evidence to point to Avery Becker. So instead, I ask you to think about Avery and Taylor's testimony. Unlike with the prosecution's story, you won't have to stretch your mind or fill in gaps to believe them. Avery just wants to move on with his life, and yet his whole world is being put on trial by a prosecution that clearly wants a conviction, regardless of the faulty and lacking evidence. Members of the jury, don't let the prosecution make Avery Becker guilty until proven innocent. Look at the evidence for yourself and see the reasonable doubt seeping through the holes in their story. Find Avery Becker not guilty. Thank you.
Thank you. Any rebuttal from the prosecution?
Yes, Your Honor, but before I begin, I inquired to the court a brief time check.
You have 45 seconds remaining.
Thank you. Ladies and gentlemen of the jury, you heard opposing counsel say, look at the testimonies between Avery Becker and Taylor Perkins. But I also encourage you to look at this testimony because their testimony was reckless and rushed. Because as you can see from the testimony about the cell phone, not only do they contradict each other on when they lost the cell phone and where they went, but they also contradict the police in their own interviews with the police, stating that they had a text conversation with their phones, the phone in question, that is Avery Becker's alibi, on March 6th, 2020. Based on that, you have no reasonable doubt that Avery Becker was at 444 South Flower Street on March 6th, 2020, and broke in to Mackenzie Rockland's residence. Thank you.
Alrighty, thank you. That concludes today's trial. So we're now going to allow everyone to score the round. If competitors want to come on screen so that they might know who they're scoring.
And Your Honor, I have submitted my score sheet.
I think we have one more panelist, if I'm correct. I've got Andrew, Kate.
I think you've got Megan Anderson as well.
Yeah, and I submitted my score sheet.
Thank you. Appreciate it. Michael, or Judge, I'm sorry, you can go ahead with feedback and I will confirm that all submissions have been received.
Alrighty, so I have been speaking this entire trial, so I'm going to turn it over to our esteemed panel of scorers. Of course, I recommend that comments be left to, around 2 minutes since this is their final round, and I'm sure they want to go home or prepare if they have to, do whatever they need.
All right, I can go first. Hello, everybody. My name is Andrew Fisher. I'm a law clerk for Chief Justice Boatwright at the Colorado Supreme Court. I graduated from CU Law back in May, took the bar exam in July, pandemic edition, and started work in September. I did mock trial in law school and in college for 3 years. I thought you all did really well. A couple general comments. I echo the let's keep it short directive. I think something that pretty much everybody could do better is vary speed, volume, and tone to either emphasize or de-emphasize certain points. So for example, on cross-examination, you have a couple questions that you really want to hit that are critical. So bring up your volume, maybe go a little bit faster or slower to emphasize. Mr. Smith, despite the fact that you were 2 miles away, you told the detective that you heard the accident. Isn't that right? So you draw the jury's attention to what you really want them to take from your presentation, and you de-emphasize perhaps less important sort of setup questions that you need to ask to get there. I thought there were a fair number of missed speculation, lack of foundation, maybe improper opinion and relevance objections. A lot of statements from witnesses that began with, "I believe," "It's my opinion." Now, when you qualify a witness as an expert, gives the witness a little bit more latitude, but that doesn't mean that, you know, speculation, lack of foundation, objections just, or improper opinion objections disappear. So there were some statements by expert witnesses that I really felt like they were not able to make, or that the directing attorneys had not elicited sufficient foundation for. So just keep an eye out for that. Witnesses, when you get asked a damning question, sometimes it's better just to concede and move on, because fighting on it draws attention to it. And so just keep that in mind. If it's bad, but it's not terrible, maybe just concede and move on, and the jury will forget about it. There was a good lawyers can't do math joke. I always appreciate that. We can't. There was a collective groan in my contracts class when we learned we had to do basic addition and subtraction and multiply numbers by 3 on our exam. Couple small things. Don't thank the judge for rulings that go in your favor. Just say, "Yes, Your Honor." And then, especially on cross, when you're asking questions, make sure you don't start the questions with fillers. This was a terrible habit of mine too. I would say, "And you said," and then you went, and. So try to just start with a question instead of a filler. You went, then you said, etc. Okay. Mr. Damon, I really liked your knowledge of the rules of evidence and your closing argument. Ms. Aguirre, I really liked your cross-examination, especially the question of the detective about confirming the alibi. I thought that was really well done. And then Ms. Kenny, you have a, casual is the wrong word, but very warm conversational style. And I think that's really good because it wins trust with the jury. So I thought that was well done. Mr. Jones, I thought you were an excellent defendant as well. And I will defer to my other panelists.
Thank you. So my name is Kate Ives. I'm probably on the other end of the spectrum from Andrew. I just retired after 30 years as a securities lawyer. So it's quite fun to do courtroom stuff for me because I started my law career clerking, and that was my favorite job I ever had. So it's fun to be back in the courtroom, even if it's just the moot courtroom. But I would say you guys all did a fabulous job. I was absolutely blown away. You know, I might compliment the witnesses because everyone always forgets to give the witnesses feedback, but I thought you guys were really, really well prepared today and kind of got into character. So that was fun. You know, the advice I might give you overall is to slow down. It's so hard to do because when you're nervous, your reaction is to talk faster. But keep in mind that the jury in a real trial has never been in a courtroom, most of them in their lives, and they're all a little overwhelmed. So slowing it down is a good thing. A weird one, I wish you guys had the experience of being in a courtroom. So hopefully some of you aren't graduating this year and we'll get to do that next year. But it's hard to do it on Zoom. And I think you guys all did really well with the technology. One thing you might think about on Zoom is gesturing a little bit, kind of grabs people's attention. You know, as Andrew was saying, it emphasizes a point. So you don't want to go crazy where your hands are just, you know, running all over the place. Claire, I agree. You had a great conversational way of talking, both in your examinations and in your closing argument. And I think that's really important. You know, you're talking to the jury, you're talking to the witness. It's kind of like you forget about everything else that's going on. And that's not to say that some of the rest of you didn't do really well at that, but just think of it like a conversation. And then the only thing that I would disagree slightly with Andrew is I always like thanking the judge when they ruled in my favor. I think it's a little trick to show the jury that you won. It goes against you if you don't get it, but I think, you know, it's all style. But I hope every single one of you goes to law school because I think you would be a credit to our profession. So congratulations, and it's incredible that you've made it this far, and I hope you get in the finals. So good luck and great job.
And I'm finally me. I'm graduating in May from DU Law, so I'm not quite an attorney yet, but I think you guys did great, and I learned from the trial today. I like the themes that both of you brought to the table: the undone, unraveled, unmasked, and then for the defense, the rushed, reckless, and filled with mistakes. I thought those were very great themes to kind of hold through the trial. I like how the prosecution kind of used that theme against the defense at the end. That was kind of a smart little, like, clever way to use their theme against them. And then I think both sides did a really great job of prepping their witnesses. As kind of mentioned before, there was great communication between the attorney who was directing the witness. And so I think that you all did a really great job. And as mentioned, you all will make amazing lawyers if you do decide to go to law school. So good luck with everything in your future endeavors.
Alrighty, I'll finish it off. So my name's Michael Wilson. I did mock trial in college, and I've been a judge ever since. And absolutely outstanding. I mean, this is just a phenomenal round. I've seen a lot of college teams that you all would smoke. I mean, this was just great. I echo everything that the panelists have said. I really love the opening statements. I think both of you made just great narratives, and you really both showed me the story of it without getting too argumentative. Ms. Inks, I think you did a fantastic job with that. And Mr. Ebel, I don't know how to say your name. You also did a great job telling the defense's story. You know, you didn't spend too much time on their side. You told your narrative. So excellent job from both of you. And then just because I don't think it's been mentioned, Detective Markowitz, I played a detective in college. I know how difficult it is. You're always the bad guy. I think you did a great job when you marked up the exhibit. You really showed me the story, and that was excellent. And then Ms. Owen, I also played experts at college. Phenomenal. You were just so believable. You were so credible. I mean, I just bought into it like that. And I thought you just had a great demeanor. But honestly, if I didn't mention you, you did a great job. You were fantastic. I think you were all excellent. And I'm going to say, please apply to the University of Michigan. If you haven't already and you're not graduating, they need more people like you. So please, but just phenomenal round.
Please apply to Hamilton College in Clinton, New York.
Okay, and at that, I think we're all done. So I think you're all free to log off and go our separate ways. So
You are dismissed. Enjoy your afternoon.
Thank you so much, everyone.
I just want to say real quick before everyone leaves, thank you all for judging, and thank you for giving us a platform to compete this year during this really, really weird time that we're in right now. And as this is like a really big passion for some of us, myself included, getting to actually compete and work as a team this year and compete against actual teams like this. Thank you all so much.
Completely. It's been amazing.
You're welcome. And I'm going to stick my email in the chat box if any of you would like to get in touch for more detailed feedback or to chat about law school or whatever. Have a good afternoon, everybody. Good luck.
Thank you.